All right, picture this. You've just received a decision from a major government agency, and it's not good news for your client. The clock is officially ticking. So what's your next move? For countless lawyers here in the Philippines, the answer is Rule 43. In this explainer, we're going to break down this absolutely critical part of the rules of court so you know exactly how to handle it.
So yeah, this is the classic scenario, right? It could be the Civil Service Commission, it could be the SEC. An unfavorable decision can feel like you've hit a brick wall. But here's the thing, it's not the end of the road. Your path forward, your appeal, is governed by a very specific and very powerful tool, Rule 43.
So here's our game plan. We'll kick things off with the absolute basics. Then we'll map out its scope, who it covers, and, just as importantly, who it doesn't. After that, we'll walk through the step-by-step procedure, see how it works in practice, and I'll show you the common traps that can completely derail an appeal. And finally, we'll boil it all down to one essential takeaway. Let's get into it.
All right, first things first. What is Rule 43 really all about? Before this rule existed, appealing from different government agencies was kind of a chaotic mess. Everyone had their own rules. Rule 43 was created to fix that. It provides one clear, uniform pathway for appeals from a whole list of powerful agencies.
The best way to think about Rule 43 is as a procedural bridge. Seriously. On one side of the river, you have these quasi-judicial agencies making incredibly important decisions. On the other side, you've got the Court of Appeals. Rule 43 is the only bridge that connects the two. It's all about creating order and a predictable process.
Okay, now let's get into the nitty-gritty. Which agencies and what kinds of cases are we actually talking about here? Understanding the scope is absolutely the first step, because if you get this wrong, your appeal could be dead on arrival. First up, let's just demystify this term quasi-judicial agency. I know, it sounds like a mouthful. But in simple terms, it's just an admin body that acts kind of like a court. It hears evidence, it looks at facts, it applies the law, and it hands down a binding decision. And because these agencies have so much power, their decisions need a formal, standardized appeal process. That's where Rule 43 comes in. And we are not talking about small-time agencies here. I mean, look at this list. These are the heavy hitters of Philippine administrative law. You've got the Civil Service Commission, the SEC, even the Office of the President. That's why, no matter what kind of law you practice, you've got to know your way around Rule 43. So, Rule 43 is your go-to whether the agency messed up on the facts, the law, or a mix of both. But, and this is a huge but, there is one massive exception you have to burn into your brain: labor cases. Decisions from the NLRC are a different beast entirely. As the Supreme Court made clear in St. Martin Funeral Home v. NLRC, the right way to challenge those is through a Rule 65 petition for certiorari. It's a classic bar exam trap, so don't fall for it.
Okay, we know the what and the who. Now let's talk about the how. This is the procedural heart of Rule 43. And trust me, you want to pay close attention here because one tiny misstep can be fatal to your entire appeal.
If you remember only one number from this entire explainer, please make it this one: 15. You have exactly 15 days from when you receive the judgment or the denial of your motion for reconsideration to file. This deadline isn't a suggestion. It's jurisdictional. You miss it, and you're done. Now, the rules do throw you a small lifeline. You can ask for a one-time extension of another 15 days. But here's the catch. You have to file that motion for extension and pay the fees before your original 15 days run out. Don't be late on that either. Think of this as your launch sequence. It all kicks off with filing a verified petition for review. Then you pay up. After that, you serve copies to the other party and the agency. But really, pay close attention to step 4. Making sure your petition has every single required attachment is where so many appeals stumble right out of the gate. Get all that right, and the ball is finally in the Court of Appeals court. Okay, that's the theory. But let's make this real. How does all of this actually come together in a practical scenario for a lawyer and their client? Let's use a classic example. A government employee gets dismissed from their job and the Civil Service Commission agrees with the dismissal. The lawyer gets that decision on October 1st. The countdown begins. They now have until October 16th to prepare and file a complete, perfect, verified petition for review with the Court of Appeals. It is an absolute race against the clock. Now, this is a doctrine that will shape your entire appeal strategy. Section 10 basically says that the Court of Appeals will not second-guess the agency's findings of fact as long as they are supported by substantial evidence.
And what's that? Well, the bar is pretty low. It's just enough evidence that a reasonable person might accept it as adequate. So the big takeaway for you is don't just re-argue the facts. The Court of Appeals doesn't want to reweigh everything. Your best shot is to focus on where the agency made a clear error of law. All right, let's talk about the landmines. This is probably the most important section for any bar reviewee or practitioner. Why? Because a simple procedural mistake here can get your entire case thrown out, no matter how strong your arguments are. Pay very close attention to this list, because this is where appeals go to die. These aren't minor technical issues. These are grounds for immediate, outright dismissal. You forget to pay the full docket fee? Gone. You fail to attach a certified true copy of the decision? Gone. You miss that sworn certification against forum shopping? Your case gets tossed before a justice even reads page 1 of your petition. And here is another huge pitfall. Section 12 is crystal clear. Just because you filed an appeal does not mean the agency's decision is put on hold. It can still be enforced. If you want to hit the pause button, you have to file a separate motion and convince the Court of Appeals to issue a stay order. That is a critical strategic move you cannot forget. Okay, we have covered a lot of ground. So let's boil it all down to the absolute essentials. What is the one thing you need to walk away with when it comes to Rule 43? Here it is. If you take away just one thing, let it be this. Rule 43 is your one standardized road to the Court of Appeals, but it's a road with a very strict speed limit and a lot of potholes. Your success really comes down to 3 things. Know the scope, treat that 15-day deadline as absolutely sacred, and be a perfectionist with your paperwork. Get those right, and you've already won half the battle. So we've mapped out the path. But knowing the rules of the road is one thing. Driving skillfully is something else entirely. The real art isn't just about filing on time. It's about crafting a petition that is so clear, so persuasive, that it compels the Court of Appeals to see the case your way. And that's where procedure ends and the art of advocacy truly begins.